Good morning. Thank you, Ben. So, a lot of people, when they give a talk on medical futility, start with this cartoon slide, right, where you have a physician with a stethoscope leaning down at a gravestone with the wife of the decedent standing over him, and he's telling her, "I'm afraid there's really little I can do." And the reason this is apt is because the problem of medical futility is often framed as one of surrogate-driven overtreatment. And what I mean by that is that the clinicians have determined that the appropriate treatment plan, the appropriate course of action is comfort measures only, but the family, the surrogate, however, wants to continue life-sustaining medical treatment. And so the two other main distinctive features of a paradigm medical futility conflict are that it usually involves a patient in the ICU, mechanical ventilation, artificial nutrition, hydration, and so forth. And secondly, the population of patients that we're talking about who are the subject of a medical futility dispute almost always lack decision-making capacity. Thus, the medical decisions are being made by a surrogate. So here's my roadmap for the next 20 minutes. And basically what I want to give you are the four basic dispute resolution pathways by which a medical futility conflict can be resolved. Right? Ideally, first, you can prevent it from arising in the first place. You can try to reach consensus between the clinicians and the family. You can switch the parties, and then finally, I'll spend a good bit of time, since I'm a lawyer, talking about what to do when none of the first three things work and you have an intractable conflict. So first, right, if we can prevent a conflict from arising in the first place, that's best than rather having to try to resolve it after it's already arisen. And this is intuitively really appealing because most patients actually don't want futile treatment. What a lot of medical futility is a result of is the fact that the care that patients get, and this is probably U.S. focused, but I don't think these issues are unique at all to the United States, probably equally true here, is that the care that they get is not the care that they want, right? And so when they give all these patients fetal care, and somebody just presented the UCLA study a few minutes ago where 20% of patients in the 6 UCLA ICUs get fetal treatment, most of them didn't want it, right? So it's not that the patients themselves are asking for this treatment, it's the surrogates asking for this treatment. So one way to prevent medical futility conflicts would be to get and hear from the patients themselves. And a key way to do that is to do more advanced care planning, better advanced care planning, and earlier advanced care planning. And one of our key ways to do this in the United States is with the PULSE program, which works a lot better than advanced directives because they're immediately actionable, while advanced directives need to be interpreted and then translated into medical orders. Here that step is eliminated, and these work a lot better to assure that patient preferences are honored. Unfortunately, there are some real limits to prevention as a dispute resolution pathway. We have a big research survey organization, the Pew Charitable Trusts. They published a study recently called Views on End-of-Life Medical Treatments. Our advanced care planning completion rates are pretty low. This is from different age groups. It gets a little bit better when you get older, but still this is pretty mediocre, and it really hasn't been going up too much. And in fact, this is actually the rate at which people complete advanced directives. And actually, we took a survey a few minutes ago. People raised their hand. Oftentimes, it's useful to follow up that with how many people did it correctly, meaning where is your advanced directive? Is it locked away in a drawer where nobody knows where it is, right? So this is just the people who did it. How many of these are actually going to be available and useful and instructive at the relevant time. The other thing that the Pew study showed is that around 30% of the U.S. population actually wants all aggressive treatment possible to keep their biological life going as long as possible. So even if we increased advanced care planning, some people are actually going to document in their advanced care plan that, in fact, they want everything possible, even if their clinicians think it's medically inappropriate. Bottom line is disputes will arise, right? There's some real limits to prevention. So if you have a dispute, well, then ideally, and in fact most of the time, thankfully, consensus can be reached between the surrogate and the clinician, right? With ongoing negotiation, maybe mediation with a third party like an ethics consultant or palliative care consult. The good news is in these studies, consensus is reached almost all the time, and there's only a small subset of futility conflicts that remain intractable. And there's been a number of studies published over the last few years. One of the most recent ones from Kaiser Permanente, which is a big system in California. They started off with around 100 futility conflicts. After one meeting, a family meeting with the team and the family, consensus was reached in 70 of the 92. After another meeting, an additional 9, everybody was able to get onto the same page. After a third meeting, went down to 8. So anyway, after 3 meetings between the team and the family, only 5, if you look all the way to the right, only 5 of these original 92 cases remained intractable. Agreement had been reached in all the other cases. And this has been published. The same exact numbers basically have been replicated in a number of other studies in other parts of the country. One of the biggest ones in Texas, they looked at around 3,000 medical futility conflicts in 10 hospitals. Only around 60 remained intractable. So consensus was reached in overwhelmingly almost all of these cases, right? 95% is the number that usually comes out of the published studies, which means only 5, if my math's right, only 5% of futility conflicts remain intractable. Only in 5% are the clinicians and the family unable to reach consensus. And I should say, when I say reach consensus, what that usually means is the family coming over to agree with the clinicians, not the clinicians coming over to agree with the family. So now I'm going to focus primarily now on this 5%, right? These are the really tough cases, the ones that cause, and I think some other people are talking about moral distress. These are the ones that really cause problems in the facilities. So what can you do in this 5%? Right, you're unable to prevent the conflict and you're unable to reach consensus. Well, one thing you can do is switch the parties, right? Because the conflict is between the current treatment team and the current surrogate, right? But maybe if you can switch either the attending physician or if you can switch the surrogate, then you can line up and maybe the new decision makers will agree with each other. So I'm just going to look at each of these paths. These are the accepted pathways used all the time in the United States for resolving these conflicts. So get a new clinician. And the way in which this is done is the current treating clinician doesn't want to provide the life-sustaining medical treatment that the surrogate is asking for. Well, maybe there's another clinician somewhere else, maybe at another hospital, who is willing to provide the treatment that the surrogate wants for the patient. So it's not very often you can find these clinicians who are willing to take these cases that you don't want to have, but sometimes you can. And so generally people usually at least look for that. And the reason it's possible to sometimes find these transfers is because, and I'll come back to this theme, is because there's so much variability among institutions and among clinicians in the United States. In other words, what you think is medically appropriate may not be what somebody else thinks is medically appropriate. There's not a lot of consensus about what the right thing to do is or what the right population of patients for whom mechanical ventilation or dialysis is indicated for, right? Different clinicians have very different opinions, so it's sometimes possible to make a transfer. The other thing, which is more common as a dispute resolution pathway for medical futility disputes, is to replace the surrogate. Now, the general job of a surrogate is to stand in the shoes of the patient. And in the United States, generally what surrogates are supposed to do as a matter of law is to, if possible, exercise substituted judgment, right, and figure out, based on the patient's preferences, values, and known wishes, what would the patient have decided if she had capacity and was able to make the decision right now. And if you can't make the decision on the basis of substituted judgment, then at least to make it on the basis of objective best interests. And dozens of studies show that surrogates are terrible at this. Their accuracy rate is horrible, and oftentimes barely better than pure chance. The other thing that these studies show is that surrogates overwhelmingly, when they make different decisions than the patients would have made for themselves, the error leans in one direction, which is surrogates make overwhelmingly more aggressive treatment decisions than the patients would have made for themselves. So that's just background. There's three main reasons why surrogates get replaced. One is real easy, and that's because the surrogate has a conflict of interest, right? It could be a financial conflict of interest. We have, sadly, lots of cases in the pediatric and context in which a parent has abused the child, right, beaten them, and the life-sustaining treatment decision is the result of the abuse, and therefore, if the parent consents to stopping life-sustaining treatment, they could be charged with murder instead of whatever lesser charge they're currently facing. Another clear situation is where you have a patient who has left pretty clear and applicable wishes about their life-sustaining treatment, and basically the advance directive says no, right, in situation A, which is the situation they're now in. I don't want this aggressive treatment, but the surrogate is saying to the clinicians, provide it, right? There, the surrogate is clearly contravening her authority and should be and can be replaced. A little bit tougher is where the surrogate isn't contravening the clear and express instructions in an advance directive, but is just acting inconsistent with what everybody has determined to be the patient's best interests. Surrogates also replaced in this situation. And just in the last 2 years in the United States, we have at least 10 to 20 published court cases in which surrogates have been replaced in these sorts of situations. So it's an accepted and successful dispute resolution pathway, but there are some real big limitations. One is, going back to what I said a second ago, the real lack of adequate advanced care planning in the United States means that providers often can't show any deviation, right? They can't show that the surrogate is deviating from the patient's known wishes because we don't know what the patient's known wishes are, right? So you can't show that the surrogate is contradicting them. Just don't know. Secondly, surrogates get the benefit of the doubt, right? So, and this applies a lot when you're operating under a best interest standard. If they're clearly asking for something that's way aggressive and is going to pose substantial burdens for zero or close to zero potential benefit, where you have a very lopsided burden-benefit balance, then maybe you can say that the surrogate is acting inconsistent with patient best interest. But oftentimes it's not so lopsided, and in the closer gray line situations, the surrogate generally does and should get the benefit of the doubt in doing that weighing. And finally, the other big limitation on using surrogate replacement as a dispute resolution pathway in futility disputes is that sometimes the surrogates they're good surrogates. They're loyal and faithful. They're doing what they're supposed to be doing. And the big situation here is religion, right? So if you have, for example, a Muslim patient, and the reason that the family is asking for continued life-sustaining treatment is because of the patient's own Muslim beliefs, well, then they're doing exactly the same thing that the patient would have wanted to do for himself. They're good surrogates, really. There's no basis to replace them. They're doing what they're supposed to be doing. So if you can't prevent the conflict, and you can't reach consensus, and you can't find a transfer to another willing facility, and you can't replace the surrogate, now you have a truly intractable conflict. And so here you have, I'm going to break this part down, you have 3 dispute resolution pathways for a truly intractable conflict. You can act covertly, you can act without consent, or you can just cave in and do what the surrogate wants you to do. So covert action, what I mean by that is, well, what it sounds like is you're going to go ahead and withhold or withdraw treatment, but you're not going to seek consent for it, and you're just going to be sort of secretive about it. And in one study, it's probably still the biggest cited study on this point from ASH, where they surveyed over 700 physicians. 14% of them said, yes, we have withheld life-sustaining treatment on the basis of medical futility, not only without the consent of the family, but also without even the knowledge of the family. Now, in the United States, there's some real risk in this approach. And in fact, I think given the recent Tracy decision in the UK, probably also in the UK now. But in this situation, it's worth noting that in medical futility conflicts, providers have won almost every single damages case for unilaterally withholding, withdrawing. But in the subset of cases that have been brought, the cases they've lost have been for negligent infliction of emotional distress and intentional infliction of emotional distress. And there, the idea is that you're acting in a secretive, insensitive, or outrageous manner. It's not that you're being sued and you're losing the lawsuit because of unilateral withholding, withdrawing. It's that you did so in this manner because consultation is expected and distress is foreseeable. So if you're going to do it openly and transparently, in the United States, I like to say there's basically 3 main ways, or 3 main laws that govern whether and how this can be done. And I use a traffic light, red, green, yellow, to do this. Green means that, yes, you may go ahead and unilaterally withhold or withdraw without consent. It's safe to do so. And the main example of that is Texas. The Texas law says since 1999, you may stop life-sustaining treatment for any reason with immunity, so long as your hospital ethics committee agrees with you, attending physician. All you have to do is provide the patient or the family 48 hours notice of the ethics committee meeting. The ethics committee usually agrees with the attending physician. They'll write this up in a written decision, give that to the family. The family then has 10 days to try to transfer. Usually can't find a transfer. The treating facility can withdraw life-sustaining treatment on the 11th day. It's been used quite a bit over the past 15 years. And in fact, many other states across the United States have looked to Texas as a model, right? Because physicians are able to act in the way that they think is medically and ethically appropriate, while physicians in other states feel trapped by the law. So they are asking, can't we get a law like Texas? And medical associations in California, Washington, Wisconsin, and other states have passed resolutions to do that. More formal action has been taken in all 3 branches of state government. Idaho Senate passed a bill to copy Texas. Maryland tried to do it through administrative agency regulations, and New Jersey tried to do it through the court system. Ultimately, those efforts all failed, and Texas remains alone as a jurisdiction in which physicians can stop life-sustaining treatment without consent. There is another green light in the United States, and that's that many states have conscience-based objections. So the physician is not withholding, withdrawing on the basis of professional reasons, but on the basis of personal reasons. And here the reason is because many physicians see providing continued aggressive interventions to these patients as akin to torture, right? They feel like torturers. There's one quote from the Mass General. This is the Massachusetts General Hospital, not Auschwitz, right? These are the analogies that are drawn. Many states have laws that say, yes, physician, you may stop for reasons of conscience, but those permission slips are generally conditional on treating till transfer. In other words, you can't stop until you find somebody to take over for you. And like I said, it's hard to find somebody to take over for you. For the same reason you don't think this treatment is appropriate, Most other people don't either. So if you want to refuse, you have to try to transfer, and if you can't transfer, then you have to comply with the surrogate. But it's worth noting many states, Mississippi, Nebraska, Michigan, and now Kentucky, and Oklahoma, now have removed that condition. So you don't have to transfer the patient. You can, on the basis of conscience, refuse treatment, and you don't have to transfer first. In a few states in the United States, there's also a red light, which is the opposite of green light. Green light gives you permission to go ahead and do what you think is appropriate. Red light says you always need consent. So in Minnesota, where I am, we have a partial red light. So if the surrogate has been appointed by the family, you have to follow that agent. But if it's another kind of surrogate who gets their authority otherwise, then you don't have a red light. And these have been growing in just the past 4 years. New York now has a red light, which the statute basically says if the surrogate directs life-sustaining treatment that the provider does not wish to provide, the provider shall nonetheless comply. Idaho, the same thing. Healthcare may not be denied if it's been directed by the surrogate. Oklahoma actually just reinforced its law this year, had it from 2 years ago, and Alaska tried to enact a red light. So we have a handful of states that are green light states, basically give clinicians permission to withhold without consent, and then a handful of jurisdictions that are red light states that say you absolutely may not withhold or withdraw unless you have consent. Everywhere else in the United States, which is the vast majority of jurisdictions, is what I call a yellow light state, which is it's not red, it's not green, it's just unclear, right? Physicians live in uncertainty about whether or not they may or may not withhold life-sustaining treatment without consent. Just to take California as an example, the statute says to providers, you may decline to comply if what the surrogate is asking you to do is contrary to generally accepted healthcare standards. And in fact, you have immunity. So if you use that clause, you have immunity from civil, criminal, and disciplinary sanctions. The problem in California and every other state that has a law like this is it's all your protection is linked to the fact that the surrogate is asking you to do something contrary to generally accepted healthcare standards. Well, the problem is in the United States, we don't have generally accepted healthcare standards when it comes to ICU care. There's immense variability in what physicians do and what physicians think is the appropriate thing to do. These safe harbors, and physicians want safe harbors here, right? They want a clear statement that you're safe when you do this. The safe harbors are there. They're written in the statutes, but they're structured this way, which is where the surrogate is asking you to do something that is outside the standard of care, well, then you can refuse to do that, and you're safe. The problem is we don't know, clinicians in the United States don't know if what the surrogate is asking them to do is inside or outside the standard of care. So the safe harbors are really of no value or use to them. It's actually what's worse than that is by continuing, for example, just to take UCLA again, by continuing to provide fetal care to 1 out of 5 patients in the ICU, clinicians are actually creating and reinforcing the very standard of care that they don't want to comply with. Safe harbors need to be clear, precise, concrete, and certain. And in Texas, they are, because it's 48 hours notice of the ethics committee, 10 days to try to transfer, right? It's measurable, right? You know when you've satisfied the elements to achieve the safe harbor in Texas, but California, it refers to generally accepted healthcare standards, which is vague, and you don't know, and you can't know for sure whether or not you've satisfied the safe harbor prerequisites. So physicians are still worried about liability, and one way to say this is that a yellow light, given extreme legal risk averseness in the United States, is basically the same as a red light. That's the way it's perceived and acted upon. So in the United States, our status quo is this, which is most futility disputes are resolved this way if consensus is not reached, and that's that the clinician caves in. They follow the substitute decision maker instead of doing what they think is appropriate. There have been very few judgments, very few settlements. That doesn't matter. The risk is not zero. It's a little bit bigger than zero, close to zero, but that's still enough risk to make them afraid and to cave in to surrogate demands. And it's very well documented now that clinicians, it's not just that they're afraid of liability. They probably will win these suits if they were brought, but they're not just liability averse, they're litigation averse, because the process of defending the lawsuit takes a lot of time, takes a lot of emotional energy, and other transaction costs. And in any case, it's just easier to cave in because most ICU clinicians round off, and so the patient's going to die soon. The nurses are going to bear the brunt of it. So it's just not worth it to invest the time to stand up to the surrogates, either in the clinic or definitely not in a courtroom.
Thank you, Thaddeus. We do have some time for questions. Before we go to that, I might just check to see if Dr. Stokes has arrived. No other presenters? We have more time for questions. Excellent. All right, we've got plenty, so I'll let you start.
Yeah, do you want to use the...
Yeah, actually, we are recording, so actually, if you could come to the microphone, that would be great. Just one of the earphones here as well.
Out of curiosity, can I ask about a recent case in the US, I don't know where it is, where, talk about futility, at the very extreme futility, there was a girl with diagnosed brain death who the hospital weren't allowed to cease the treatment, and in fact they had to effect that girl's transfer. I don't know whether she was a road traffic accident or what. I try to understand the context of palliative care and end-of-life care with the concept that you're describing, where someone who's actually diagnosed as brain dead, and we know what that means, they actually then can't withdraw life-sustaining measures, which seems extraordinarily futile.
Right. So first, let me make 3 points. One is the law is consistent, absolutely clear in the United States that there's no obligation to continue life-sustaining treatment once death has been determined. Right. So the law has not changed in the United States. And this was a California case. The courts did not say otherwise. Okay. So there's no obligation. Once death is determined, you can stop all physiological support. So, what happened with the High McMath case? She had a tonsillectomy and an adenoidectomy, and after the surgery went fine, but after the surgery, she started bleeding from the place where the tissues were, from the tissue that had been removed, and the bleeding. She lost her airway and suffered an anoxic brain injury, and then determined dead. The reason that the Children's Hospital of Oakland had to continue physiological support for some weeks was not an adjudication of duties and responsibilities of the clinicians. It was solely as a temporary stopgap measure. The court had issued a temporary restraining order just to preserve the status quo until we can figure out what's going on. So that the family had disputed the fact that she really was dead, right? And so the court said, well, maybe the family's saying she's not dead, and so you have to keep her, until we can figure this out, you have to keep the physiological support going. So, and that happens all the time, right? They might be wrong, but we're going to preserve the status quo until we can figure out who's right or who's wrong. So it's just a feature of litigation that sometimes you get these temporary injunctions and restraining orders. So, but in this, both the state and the federal court in California never ruled and said anybody has a responsibility to keep dead people, give support to dead people. Yeah.
I'm just wondering what. I was just wondering what recourse a patient who disagrees with the decision of the Hospital Ethics Committee has, if the decision is for the physician to cease giving treatment. And I was also interested in the process of replacing a surrogate, how that occurs, whether that's instigated by the patient's family or whether that's driven by physicians.
So you're asking why do families insist on treatment that's not being recommended by their clinicians?
No. If the hospital ethics committee makes a decision that yes, a patient's treatment should be ceased, does the patient and the family disagrees with that? Do they have any recourse?
Not in Texas. So in Texas, the ethics committee in the hospital is set up to be what you might call the forum of last resort. So it's not reviewable in court, right? So the statute literally makes them the final adjudicator. So you can't go to court and say, well, they're wrong. They made a wrong decision. Treatment really is appropriate. It's not going to be reviewed. So there, it's done, right? Once the ethics committee decides, it's it. In every other jurisdiction, the ethics committee, usually the fact that the ethics committee even provides a recommendation, for example, in California or any other state, is often very persuasive to the family, right? And they think, well, I know I heard it from clinician 1 and clinician 2 and clinician 3, and now there's this, 15 people from diverse fields here. They're also agreeing. And so sometimes they're thinking, well, maybe you guys are right? So sometimes they take that. But in every other state, they can still go and get an injunction. And then the other question was?
The process of replacing a surrogate, how does that occur? Is it driven by the physicians or the patient's family, or is it a formal process?
Well, so I'm talking about so in a futility dispute, normally it's driven by the clinicians, right? Because they think that the currently authorized surrogate, and that could be, right, somebody who was appointed in the advance directive, or it could just be, we have these hierarchies in most states in the United States. It just goes like spouse, adult child, adult sibling, and so forth. And so the person has their decision-making power merely as a feature of the law, and the clinicians think that you're acting as a bad surrogate, right? You're asking us to do bad things, and we think you're acting outside the scope of your authority. And so normally in a futility dispute, it's the clinicians that are trying to find a new surrogate who they think will be more reasonable, well, basically one who they will agree with them. And that's so they're the ones usually that are doing it. But absolutely, sometimes families, one sister thinks that the other sister is acting too aggressively to mom. There was a case at the University of Southern California where the brother was appointed, and the sister thought, well, you're not making treatment decisions that mom would have made for herself. And so she moved to replace her brother, right? So sometimes it is on the family side as well.
Pick up on that last issue you raised. In Queensland and some places in Australia, there's discussion about the idea of replacing a surrogate as payback, almost. Is that we're not getting the decision we want, so let's just get through it. And sometimes that's not necessarily done, the suggestion is at least, as a matter of sort of in a good faith negotiating discussions. Is that you're an impediment, let's just get you out of here so we can get on with business. Have there been experiences or discussions like that in the United States? Would doctors sort of initiate and say, look, it's easy for me just to get rid of you, so I can get a sensible and honest decision according to my values. There's been some discussion about that happening here. Are those discussions occurring there as well? It's a convenience issue.
Those discussions are happening. So it actually is in two things. In Texas, where you basically have this option, the argument is that you're not going to work hard to reach consensus because you don't have to reach consensus. You have this other nuclear option just to basically end up doing what you think is right. So why work that hard to reach consensus? Same issue with surrogates. If you have this other option, why sit down and try to have a second, third, fourth family meeting with this person and try to work through the issues? Let's just get rid of you right now. And the way that comes up in the United States is we have 5 or 6 states that don't have default surrogate statutes, and the debate comes up in these state legislatures where people say, well, maybe we shouldn't have these sorts of statutes because it's up to the clinician to identify the surrogate. And so you don't have to go to court to replace surrogates usually. You can just say, look, I no longer recognize, let's say there's 2 sisters, I no longer recognize you as the surrogate, I'm going to now look to you. And so people say we shouldn't really give clinicians the power to designate or identify the appropriate surrogate because of that risk that it's going to be abused, and they're just going to go with the person who is either easiest to work with or the person who agrees with them and takes all their recommendations.
Thanks for that. It was a really helpful summary of where things are in the U.S., and I think we end up with the conclusion that there's a need for change. And what I want to invite you to do, ask you to do, is tell us what would you do if somebody said, okay, you get to write the law for your state tomorrow to figure out the intractable ones. So not the pathways there, but just the intractable ones. What would you say the law should be with respect to intractable conflicts?
So, I mean, it's not a really novel answer, but it's pretty simple, right? And that's that I think, and the Jahai McMath question was a good question, right? It shows that the courts are not a good place to resolve these disputes because it's too slow, right? And so she's now kept in the Children's Hospital ICU for a month just for the court to say, in the end, the hospital, you're right. You never had to provide this treatment. Even though we win the case, we had to keep her in our ICU for a month. So that's not a good result. So the other end of the spectrum is you have a dispute resolution mechanism that is very fast, very accessible, and that's the Texas model where you just go to your own hospital's ethics committee. Unfortunately, that goes too far to the other extreme because everybody on that committee works for the hospital, is financially dependent upon the hospital, and so, and you actually some of the conflict interests that Ben was maybe alluding to. So that's a little bit basically what you have on the one end is you have too much due process with courts, not enough due process with hospital ethics committees. So I sort of like the Consent and Capacity Board. I mean, I got a nice endorsement from the Supreme Court of Canada. The only thing I would tweak about the Consent and Capacity Board, so this is sort of a tribunal, that's in between a court and a hospital ethics committee. Acts a little bit faster than a court, a little bit more nimble, is that its mandate is limited to surrogate replacement, right? So it couldn't, if the Rasooli case family brought this, I'm sorry, if Gordon Rubenfeld brought this to the doctors at Sunnybrook, brought the Rasooli case to the CCB, I don't think they'd be able to replace the wife of Hassan Rasooli because she's a good surrogate. She's doing what he would have wanted. So I would have an entity like the Consent and Capacity Board, but allow it to do more than just figure out if the surrogate is acting appropriately. I think they should also be allowed to look at, is the treatment medically appropriate? So I guess I would maybe just tinker with the Healthcare Consent Act a little bit, but have an entity like that because it's in between. It has enough due process, but not too much. So that's what I think is the right way to go. Thanks. Yeah.
I actually practiced law for 20 years in Texas and was a general counsel over a group of hospitals in Texas. And I know being on the inside, sometimes we think what we do in Texas is the best and the biggest and the greatest. But I found that when we had the ethics committees convene, we were very much concerned about malpractice lawsuits and doing the right thing because with family members there and with the doctors there, it was something that was really taken into consideration. And I do understand there is a conflict, and as a general counsel, I was always concerned about that. But I'm wondering if there is a lot of case law or if there is, materials out there that would say that the Texas model is not a good model for those reasons.
You want abuse cases from Texas? Yeah, I mean,
that the model itself at the ethics committees at the hospitals is not the.
Yeah.
I know there's instances that they weren't convened properly and that there is abuse. I'm just saying that as a model, is it because of the conflict that says it's not something that should be replicated throughout all the other states? Because clearly the Texas legislature would have changed it if it was unworkable and unfeasible.
Well, so I mean, the amount of legislative debate, it's every other year. So 2007, 2009, 2011, 2013, right? Amazing amounts of numbers of bills and 20, 30 hours of hearings in the House and Senate in Texas. So they tried. I mean, it's not like they're aware that there's problems with it. It's just politics. It's hard to get a bill passed. It is, here's the problem. So I would take back a little bit what I said about Texas. If we actually specified something in the law about ethics committees. So what Texas did is it basically delegated life and death decision-making power to the hospital's ethics committee, but it says absolutely nothing about the composition of an ethics committee, how many people are on it, who's on it, what's their training, what's their qualifications, what's a quorum, right? Anything about how or who it is and what it does. And so before you delegate that sort of power to an entity, you have to demand some level of accountability. And that they didn't do. It was very deliberate because I think it's called the Houston-Hertford problem, right? Which is, we can do this and we can mandate a 10-member minimum ethics committee for hospitals in Houston, but then on the west side of Texas, where you have you don't have the big cities, we're not sure that they're going to be able to comply. So we're not going to, it was a political compromise that we're not going to mandate that condition. So I think the authors of the legislation admit that it would be better to demand some minimum qualifications of ethics committees. They didn't do it. So if that were done, then maybe it could work better. Yeah.
Thaddeus, thank you so much. That was a really interesting talk. I like your proposal or your potential solution of having a statutory body that would determine the case rather than the inherent conflict of interest problem relating to the actual hospital ethics committee. And you just touched on what I was going to ask you. In your depth of experience in this field and looking at cases and how they're resolved, who would you want to see on a statutory body type committee determining these sorts of cases? Who are the appropriate members of such a determining statutory body committee?
So I'd refer to the Ontario Consent and Capacity Board, which is, I believe, a psychiatrist, an attorney, and a community member. And now I think that's probably a feature of the fact that this body is not limited to medical futility disputes, but is also all sorts of other incapacitated patient issues. So that's the reason for the psychiatrist.
Yeah, but this is a different kind of entity now because we're looking at determining a case that has clinical facts and as well as critical interests of the patient as a potential influence on that, as well as many other factors. So in your experience, who would you like to see on such a body?
I think that it would be the basic rules that are recommended for hospital ethics committees.
Okay.
So again, I guess I go back to that. I mean, so people have fleshed out that you want a multidisciplinary panel of at least of physicians, nurses, social work, and chaplains as a basic core, right? Now, of course, you don't want to get too big because then you lose the nimbleness. It's harder to convene. And the whole point is we want to be quick and responsive. But on the other hand, we don't want to be too quick and responsive. Okay. So it's always balancing between those. But I think you could also look to we have regulations in the United States that have been around for decades for institutional review boards on the research side, right? That has a 5-member minimum for an IRB in the United States to do human subjects research. It requires gender diversity. It requires a community member non-affiliated with the hospital. If we at least use that as a floor to identify the composition for this tribunal, I think we'd be a good way along.
Good place.